Hi, everyone. This is Michael Misko with Misko Health Law for this week's installment of the Chiro Secure Growth Without Risk series of presentations. And today we're going to talk about responding to record requests. There's a couple of things, get a lot of calls, docs that get records and, they go into panic mode. First thing, don't panic. And if you have questions about the who, the what, and the when, who's asking, what they're asking for, and when you have to submit it, or even by extension, if you have to submit it, that would be the appropriate time to call and get help. There's a couple of things relative to every record request that you have to consider, and that's what we're going to focus on here. And the first one is HIPAA. So if you're a covered entity subject to HIPAA, which means you submit electronic claims to insurance carriers for reimbursement, either directly or indirectly. So for example, if you have a clearinghouse and they submit electronically to the payers, then that makes you a covered entity. If you do electronic benefits verification through a provider portal, for example, that could make you a covered entity. And if you do electronic claim analysis or get electronic remits from the payer, that'll make you a covered entity. So to the extent that you are a covered entity under HIPAA, there's a couple of things that you need to think about with respect to evaluating whether HIPAA will even permit you to respond to the record request. Now, in HIPAA, under the HITECH Act, amendments to HIPAA, they made a change, a rather important change, to what's called the minimum necessary disclosure rule. When you get a request from a health plan, prior to HITECH, you were allowed to assume that the health plan was asking for no more information than was required to do whatever it is that they needed the records to do. As a result of HITECH, you can no longer assume that. So when you review the record request, the payer is obligated to tell you what they need the records for. I mean, are they validating whether the codes you build are supported by the documentation? Are they evaluating medical necessity, or making some other coverage determination? Because the scope of the or purpose of the record request or the analysis that they intend to do will tell you what you need to submit. So if they're simply looking to determine whether the codes submitted are accurate, the daily notes for the visits that they're requesting is probably enough. If, however, they're evaluating medical necessity and let's say they pick particular dates for each patient, well, sending them just that note, which will tell them what happened on that day, it doesn't allow them to understand where that visit fell within the patient's course of care for evaluating whether the visit was medically necessary or not. And in that context, think about it as like taking a page out of a book and then being asked from reading that one page alone, to understand what the story's about. So being that is difficult, if not impossible, where medical necessity is an issue, sometimes you end up sending them more information than they're technically requesting, but you're sending them notes that pertain to the date of interest. In the case of a medical necessity review, where when they're only doing coding, you would only send the notes that relate to that specific date, that describe the services that were billed. Now, if the description of the services are billed are in a precedent treatment order, as part of a plan of care, then you may need to send that document as well. So you have to evaluate the request very carefully. If they don't tell you what the purpose of their review is, you kind of have to stop, because that precludes you from evaluating, consistent with your obligations under the minimum necessary disclosure rule, whether you need to respond at all, number one, and number two, the scope of how much or how little you provide in terms of the patient's medical records. So that's the first thing that has to be evaluated. The second thing, and sometimes I actually evaluate this first before we even get into HIPAA issues, is participation status. I mean, ultimately, it's more relevant because your participating provider agreement, if you have one with that particular payer, will define what your obligations are relative to post-payment cooperation with their post-payment audit efforts, or utilization review efforts, or whatever they tend to call it. Now, when you're not participating, meaning you have not signed a contract with that particular payer, things are a little bit different because you have not agreed to cooperate with those efforts after the payment's been made. There's a number of legal doctrines that potentially apply, and we need to evaluate whether it makes sense to go ahead and give them the records or to resist the record request. And that is a discussion that you need to have with counsel and make sure that you understand the implications. Sometimes, if you're non-participating but submitting claims and they're assigning the payments to you, if you don't cooperate with their audit, they'll just deem the claims overpaid because you didn't send the records, and they'll start to recoup the money. And there's strategies for precluding that from happening, but those are things that you need to consider when you're non-participating and making a determination as to whether you want to voluntarily cooperate with their audit efforts. If you choose to voluntarily cooperate, one of the things you have to understand is because you don't have a contract, you don't technically have any appeal rights. So things get a little murky in that respect. There's also potentially ERISA issues if you have the appropriate financial policies where the patient has made you their representative, for what are called adverse benefit determinations. So couple of moving parts that need to be evaluated. And again, that's why when you get a request for records, that's the time to get help so that you can make sure that you understand your obligations and, more importantly, your options. The next thing that we would look at is what type of request it is. Is it a request prepayment, post-payment, or a HCC risk validation audit? I'll start with the risk validation audit. This will come from a contractor that works on behalf of a Medicare Advantage plan. Those are usually commercial insurance payers like the Blues, Cigna, Aetna, whatever. And this contractor has been hired to collect documentation to validate the HCC risk score that plan reports to the government for that patient, which then determines how much the government is going to contribute or subsidize towards that patient's Medicare Part C plan. So think of it as like insurance company coding to Medicare for reimbursement. And so they hire these companies to do what are called HCC risk validation audits. So they collect records from everybody that patient has seen, looking for diagnosis information that will validate the risk score that they've submitted to Medicare. These record requests you don't need to worry about because they're not an audit of you or your services. They just need data. And those requests you can respond to without any concern. The way you know that it is a risk validation audit is, like I said, it'll be a contractor on behalf of a Medicare Advantage payer, and you will see risk validation in the text of the letter as the purpose of what they're doing. So look for that language. And again, if you're unsure, call somebody, get help, and just to make sure that you understand whether this is a risk validation audit that you can send the records or it's not. Okay? And make sure, docs, train your staff. Unfortunately, in my business, many cases, the staff gets a request, sends the records, never tells the doc about it, and this process gets started before you've ever had an opportunity to look at it and make these judgments. And they think they're doing a good thing. Hey, they want the records, we have to send them. Well, maybe you do, maybe you don't. And if we do send them, we should probably get a look at them, and we'll talk about that, what we do in that respect in just a minute. If it's a prepay audit, this is a claim that you've submitted and the payer is requesting records to support the coverage of the services that you billed for. I mean, you can not send the records, but then you're not going to get paid either. So those type of requests usually should be responded to. But again, remember your obligations under the minimum necessary disclosure rule. Only send the records that pertain to that data service. It may be the initial exam, radiographic reports, treatment plans, and maybe any precedent or progress exams so that the payer can understand where that patient is in the plan of care and why that service is medically necessary. And the last one, which is the most troublesome, is the post-payment request. So when you look at the dates of service and their dates that have been paid, These record requests are usually oriented towards recouping money. I mean, I'd like to tell you that it's something that happens because they're looking for the next Chiropractor of the Year award recipient, but that's just not the case. I mean, they will come from the payer's SIU department or financial investigations, provider review, whatever the name of the entity is within the organization. But these folks intend to audit the records to determine compliance with their perception of their medical policies. And if they see that or think that there's a problem, they will deny the services and request recoupment of the money. And again, in those scenarios, participating status is very, very important. With respect to the scope of the request, what you need to include, again, that depends on the purpose. We've kind of covered this, but make sure that you're providing sufficient information relative to the service or services that they're asking for, depending on what they're looking at. Again, if they're looking at coding, treatment order, and the treatment notes, probably all you need. If they're looking at medical necessity or other issues, then maybe to see who the provider that actually performed the service, was the service delegated. And again, payers aren't very good at disclosing the purpose of their audit because they don't want to be constrained, but you can force them to do it. Some major no-nos when, let's assume you've decided that it's appropriate to send records. Some of the biggest mistakes providers make is they look at the records, they see errors, and they endeavor to just go in and fix them. Okay? That is a Title 18 crime. It's called a false statement related to a healthcare matter. Please don't do that. Had a number of cases in my career where a simple overpayment case, it was just about money, became a criminal case that cost 15 times as much to resolve and was way, way scarier over the simplest of goof-ups. In one case, the provider handed a stack of records and a stack of bills to an associate and said, go through these records and make sure that the stuff that we billed for was actually recorded in the notes. And rather than do that, the associate took a shortcut, and this is in the paper notes days, just hand wrote in the procedures in a remarks section of the notation. Well, the worst part of this story is that in 99% of the cases, the procedures were documented. And this addendum or this extra information that was put into the note wasn't even necessary. But because the notes were altered after the fact, it was pretty obvious that they were. The case got referred to the Department of Justice, and it was a very, very long, drawn-out process getting that resolved because the Justice Department went through a series of issues, that came out of their analysis of these records. So please don't alter your records. If there are mistakes, missing information, things of that nature, you need to further describe, maybe what exercises or therapies or where manipulation was performed or things of that nature. There is a process called the addendum process where you draft a separate document. You indicate the date that document was prepared. Note the patient, the date of service, explain what the addendum is, how you know it's true, and then you include an attestation statement. That's the best you can do. If you have handwritten notes that are hard to read, you can provide transcriptions and attest that the transcription is accurate, but it actually has to be accurate. You cannot add words. The only thing that you can do is if acronyms are used, you could spell those out. But otherwise, it's got to be an exact transcription of what's written on the paper. If you need to explain it beyond that, then you would do that through an addendum. Another big no-no is ignoring the request, hoping it goes away. It usually does not. And similarly, if you get on this, you get everything submitted, and then you don't hear anything, the next big major no-no is calling them to ask them, like, hey, what's going on? Okay, once you send the records, let it go. Occasionally they forget about you because something else more important is going on, and they put it aside, and then they forget about it. And the longer that thing sits, the better it is for you, because many states have look back limitations based upon the date they make a demand and the date versus the date of payment. So time is your friend in these cases. Get your records submitted. If you need more time, call and ask them. Get an extension. But get the assuming you have an obligation to submit the records, get them submitted, and then we just sit on our hands and we wait. If they're going to publish a result, they will. Very rarely, if they don't find what they're looking for and shut down the audit, very rarely will you get a letter saying, hey, everything was fine and the audit is closed. That almost never happens. In the meantime, you're sitting on pins and needles for probably 18 months, and at that point, if you haven't heard anything, you're probably not going to. The longest delay I ever had was 2 years, and by the time they got back to us, I mean, that added about a number of additional legal defenses that precluded recovery, and we got the issue disposed of. But don't go rapping on their door saying, "Hey, I was just wondering how the audit's going," and bad idea. Okay, so that's pretty much all we have time for today. I hope that was helpful. Keep these things in mind. I certainly recommend having formal policies that you train your staff in terms of how to react. Make sure you have somebody available that you have a relationship with that can advise you, because when these things come up, you're going to need help rather immediately. So having somebody, an outside compliance contact or something like that, who can effectively advise you on how to handle these things. And when you're finding that somebody, make sure that they have substantial experience in post-payment audit defense, because that is critical. There's a lot of people that think they understand how to prepare records for a payer, but without that experience dealing with how payers react, you're pretty much shooting an arrow in the dark. So that's all I have for you this time. We'll talk to you next month, and have a great day.